Testimony you're about to give will be the truth, the whole truth, and nothing but the truth. So,
Yes.
state your name, please.
Travis Kennard.
Sir, it is this court's understanding that you're going to plead no contest to the charge of aggravated assault. That is a misdemeanor, punishable by up to 1 year incarceration or $1,000 fine plus court cost. Do you understand that?
Yes, Your Honor.
All right. Do you understand what a no contest plea is?
Yes, Your Honor.
All right. Two things about it I have to make sure that you understand. The first thing is it means that you're not further desirous or wanting to contest this charge. Understand that?
Yes, Your Honor.
Second thing you need to understand is that for purposes of sentencing, the court will treat you the same as though you had pled guilty. You understand that?
Yes, Your Honor.
All right. You also understand, sir, that while I'm taking your plea, I would not be your sentencing judge, and you would be sentenced before Judge Barr at the 1482 District Court.
Yes, Your Honor.
All right. Still wish to plead no contest?
Yes, Your Honor.
Basis for the no contest plea?
Potential civil liability, Your Honor.
And sir, to that charge, how do you plead?
No contest.
You understand that by pleading no contest, you will not have a trial of any kind.
Yes, Your Honor.
You signed an advice of rights form, is that correct?
Same thing? Yes, Your Honor.
Any questions regarding those rights?
No, Your Honor.
Please look at paragraph 5. You'll see a copy on the podium. Those are your rights, which are part of a trial. You understand that by pleading no contest, you're giving up those rights as well as all the rights of that.
Yes, Your Honor.
You understand you're giving up your right to appeal of right.
Yes, Your Honor.
Are you on probation or parole?
No, Your Honor.
Has anybody promised you anything other than what's been stated here today on the record to get you to plead?
No, Your Honor.
Anybody threaten you or coerce you?
No, Your Honor.
You're doing this voluntarily
Yes, Your Honor.
and of your own free will.
Yes, Your Honor.
All right. Court has been handed and has reviewed Ypsilanti Police Department report. Ypsilanti Police Department report for their case number 25-15700. Any objection to the court having reviewed that?
No objection.
Based upon a review of that report, the court does find that there's a sufficient factual basis on which the court could determine the defendant's guilt of this offense. Sir, I would have to advise you that if between the time of my acceptance of your plea and the time of sentencing, if you commit misconduct as defined in the Michigan court rules, the court would no longer be bound by any sentence evaluation or recommendation, and you would not be entitled to withdraw your plea. You understand that, sir?
Yes, Your Honor.
Is counsel aware of any other promises, threats, or other inducements which have led to this?
No, Your Honor.
And have I complied with the court rule?
Defense is satisfied, Judge.
Court will accept the defendant's plea of no contest to count 2. Count 1 is dismissed. Pre-sentence investigation and report is ordered at 1482 probation. Sentencing in this matter will be
March 4th at 10 a.m.
March 4th, 2026. I'm sorry. Time 10 a.m. before Judge Barr. Bond will continue. Thank you. And counsel, can you, and to all of the PDs, but I should have said this earlier, you make sure that all of your clients have the contact information for the public defender. There's been a rash of cases in which they have not contacted, I should say probation department. They have not contacted the probation departments, and I don't want to have to take any further more drastic action, but I will. But I'm hoping you can be cooperative in that process. Ms. Second, can you?
I absolutely.
I think all of the rest can.
Your wish is my command, Judge. Your command is my.
That is so. You are so. That has never been your position in this court. Thank you, though. Wow. Court calls the case People versus Christopher Lambros.
An Assistant Public Defender, Jay Bellinger, on behalf of Mr. Lambros, who approaches.
Good morning.
Can you state your name for the record?
Christopher Lambros. Thank you, sir. I have before me the plea form. Indicates that he's going to be pleading guilty to the charge of OWI second. That's the 1 year offense. Upon his successful plea to that charge, count 1 would be dismissed. That's the court's full understanding of it.
That's our correct understanding as well, Your Honor. You're correct. Thank you.
May I have him sworn?
Right hand. Do you solemnly swear to affirm the testimony you're about to give the truth, the whole truth, but the truth so help you God?
Yes, sir.
State your name, please.
Christopher Lambros.
Sir, it is this court's understanding that you're going to plead guilty to the charge of operating while intoxicated, second offense. That is a misdemeanor punishable by up to 1 year incarceration, a $1,000 and up to a $1,000 fine plus court costs. The court could order community service or any rehabilitative services the court deems necessary. The court could order your vehicle immobilized, could order your vehicle forfeited, could order you to pay the cost of the prosecution as well as the cost of any emergency governmental services. You understand that?
Yes, sir.
You also understand, sir, that while I'm taking your plea, I would not be your sentencing judge, and you would be sentenced before Judge Washington in the 14B District Court.
Understood.
Still wish to plead guilty? And to that charge, how do you plead?
Guilty.
And you understand that by pleading guilty, you'll not have a trial of any kind.
Yes, sir.
You signed an advice of rights form, is that correct?
Yes, sir.
Any question regarding any of those rights?
No, sir.
Please look at paragraph 5 on that form. Those are your rights which are part of a trial. You understand that by pleading guilty, you'll be giving up those rights as well as all the rights on that form.
Yes, sir.
You understand you're giving up your right to appeal of right.
Yes, sir.
Are you on probation or parole?
No, sir.
Has anybody promised you anything other than what's been stated here today on the record to get you to plead?
No, sir.
Has anybody threatened you or coerced you?
No, sir.
You're doing this voluntarily
Yes, sir.
of your own free will
Yes, sir.
and because you believe that you're guilty of this offense?
Yes, sir.
On July 16, 2025, at the location of Holmes Road near North Pasadena Street, Ypsilanti Township, Washtenaw County, State of Michigan, were you operating a motor vehicle?
Yes, sir.
Prior to operating that motor vehicle, had you ingested a controlled substance?
Yes, sir.
What was that?
Okay.
And did you know that's what you were ingesting?
Yes, sir.
Were you stopped by the police or was there an accident?
Police stopped me.
Why'd they stop you, sir?
Erratic.
Pardon?
I was driving erratically.
All right. You're not disputing the right of the police to stop you in this instance?
No,
are
sir.
you?
No, sir.
Were you ultimately arrested?
I was taken to the hospital.
Cuffs?
Yes.
Then it's probably an
Yes,
arrest.
sir.
Yeah, okay. So, and then you were taken to the hospital and there was a blood draw?
Yes, sir.
All right. And did the results of that blood draw show the presence of cocaine and or its derivative?
Yes, sir.
Do you have any reason to dispute those blood test results?
No, sir.
And sir, had you previously been convicted of operating while impaired on or about September 23rd, 2023 in Ferndale and or operating with the presence of a controlled substance on or about June 16th, 2020 in the city of Ann Arbor?
Yes.
Next case, Travis Kinnard steps up for a no contest plea to aggravated assault. The judge explains that plain no contest means no trial, and sentencing treats it like guilt. Then the judge warns, mess up before sentencing, and the deal can vanish instantly.
Sir, I do have to advise you that if I accept your plea in this case, and you commit misconduct between the time of my acceptance of your plea and the time of sentencing, that the court would no longer be bound by any sentence evaluation or recommendation, and you would not be entitled to withdraw your plea. You understand that, sir?
Yes, sir.
Counsel, are you aware of any other promises, threats, or other inducements which have led to this plea?
No.
None, Your Honor.
And have I complied with the court?
Yes.
Yes, Your Honor.
Court will accept the defendant's plea of guilty to count two. Count one is dismissed. Pre-sentence investigation and screening and assessment is ordered at 14B. Sentencing in this matter will be
March 26th at 10 a.m.
March 26, 2026, 10 a.m. before Judge Washington. Bond will continue.
Thank you very much.
Court calls case People versus Tavion Lewis.
Your Honor, Raymond Cooper.
I can really, Your Honor, on behalf of Tavion Lewis. Lewis, the director.
Thank you.
Your Honor, we respectfully request that this matter be set for preliminary examination.
Your discovery is complete.
To our knowledge, Judge, yes.
Other witnesses available the third. Preliminary examination will be set March 3rd, 2026, in person, 9 a.m. before Judge Perry.
Okay, wonderful. Thank you, Judge.
Bond will continue.
Okay.
Wishes her command, really? Court calls the case, People versus Jimmy Ray Lips.
Assistant Public Defender Jay Bellinger on behalf of Mr. Lips who approaches. Can you state your name for the record?
Jimmy Ray Lip.
Thank you. He's waving.
He is, Your Honor. There has been an agreement to no MDOC on this matter upon contingent upon a waiver.
Sir, you're waiving your right to a preliminary examination,
Yes, sir.
and you understand that a preliminary examination is a proceeding where the people would have to show by probable cause that the offense alleged was committed and that you committed it.
Yes, sir.
You understand that you'll not have that hearing, you'll proceed to circuit court for further resolution.
Yes, sir.
People also waive their right.
Yes, sir.
Preliminary examination having been waived, defendant bound over to circuit court on a single count.
Your Honor, we acknowledge receipt of information, wait for a reading, stand mute at this time.
Defendant having waived for reading, standing mute, court will enter not guilty plea. Pretrial will be set for.
April 21st at 1:30.
Excuse me, let me just cross that out. What?
April 21st at 1:30.
April 21st, 2026, 1:30 for Judge County. Bond will continue. Thank you. Court calls the case of the People versus Khalid Mahmood.
Assistant Public Defender Jay Bellinger on behalf of Mr. Mahmood, Khalid Mahmood.
Thank you.
And Your Honor, we are just seeking an adjournment. We are awaiting potential discovery on this matter.
Potential discovery.
Potentially it exists, potentially it doesn't.
There are times you just want to shake him.
My mother did that when I was a babe.
So this is video outside of like police video and everything.
It is
It's a third
potential.
party. Okay.
It's potential
Makes-
video from
I get
inside the jail, Your Honor.
Then an OWI second offense plea starts and the judge walks him through every consequence: jail time, fines, costs, even vehicle penalties. The judge grills the facts: driving erratically, hospital, blood draw, controlled substance confirmed. Clean and direct, no shortcuts in this courtroom.
Oh.
So it may not exist at this point.
The incident date was back in the fall. It doesn't appear.
Got it.
Pittsfield case doesn't appear. At the time it occurred, that video was obtained at Pittsfield, so I tasked
So-
the OIC to see it.
Gotcha. All right. Probable cause conference will be adjourned March 12th, 2026, 9 a.m. Bond continued.
And Your Honor, I'm sorry to bring this to the court's attention. My understanding, and I wanted to see if I might be able to get a sooner date, because my understanding is that he's already set for a preliminary examination on March 10th on his other matter. And I wanted to,
On March 10th?
that is my understanding.
Okay.
And so I wanted to see about getting a sooner date.
So that this has to go
Yep.
forth, it can, is it,
That's, I expect, I was emailing with the OIC yesterday, probably a quick answer, yes or no, and if it exists, we get them quick, so that's fine. If we want to go to the 5th on Mr.
That way we'll know. Okay.
okay, so follow along. We're gonna know by next week, right?
That's fine, yeah.
So just to keep everything, I see what you're trying to do, Mr. Bellinger. Most of the stuff you do, I don't understand, but this one I might. So February 26th. So adjourn this to next week, 2026 at 9. That way, if it's not there and you want to set for an exam, it would go to its natural date on the 10th.
Thank you very much.
All right. Done.
Okay, that's okay.
Court calls case, People versus Trayvon Marshall.
For the judge, Portia Feaster, Assistant Public Defender, attorney on behalf of Mr. Marshall, who should be approaching. When you arrive, please state your name for the record.
Trayvon Marshall.
Thank you, Judge. I've spoken to Mr. Marshall. My understanding is he would like this matter set for preliminary examination. I believe all discovery is complete.
People have their witnesses available the 3rd. Preliminary examination in person will be set March 3rd, 2026, 9 a.m. before Judge
Judge Rushhour.
Fresh hour. Bond will continue.
Thank you, Judge.
Thank you.
March 3rd.
Court calls the case of the people versus Keith Moore.
Good afternoon, Your Honor. Raymond Cook to the people.
Michael Gandy, Assistant Public Defender, or Your Honor. Your Honor, may we approach briefly?
Yeah.
What I would see.
Understood. We will address that, Judge.
All right.
Believe
And sir, if I'm wrong on any of that, let me know.
Right.
Yeah, no, I know. All right.
I believe this is the first PCC, Judge. We'll be requesting a brief adjournment to discuss it further.
All right. Bravo Cause Conference. I'll set it out to the 12th unless you can't wait. March 12th, 2026, 9 a.m. His bond will continue.
Thank you, Judge.
And young lady, I expect that by next time you'll teach your man how to act right before he comes back in here. All right? Thank you. Across the case, people versus David Olson.
Assistant Public Defender Jay Ballinger on behalf of Mr. Olson, who should be in appearance via Zoom, Your Honor.
Yes, it looks like he is.
And Your Honor, Mr. Olson.
State your name.
David Olson.
Thank you.
And Your Honor, we are just requesting an adjournment. We just got some better contact information for our client, so we would just need some time to talk.
March 19th, 2026, 9 a.m.
Thank you very much.